This is a quick review of client-lawyer relationship. Let's start off with the formation. A lawyer-client relationship is formed by either an express agreement between the two parties, and that can be oral or written. It could be implied by the lawyer's conduct as well. If the lawyer shows to the client that he is representing that very client, that could be an indication of a formation. Moreover, prospective clients, there is a duty that the lawyer has to keep confidential information if the prospective client has supplied or provided us information during consultation with the lawyer. Therefore, the lawyer may have to, in this case, deny representation if there is a if there's a client whose interest adverse to a prospective client. Say, for example, a prospective client has opened up about their divorce case with his wife, and the lawyer has acquired that confidential information. If the wife later on comes to the lawyer and wants the lawyer to represent her in a divorce case against her husband, because the husband has already been to the lawyer as a prospective client, which the formation didn't materialize, that information that the lawyer has had from the husband is confidential. Therefore, he may have to turn down representation of the wife. Scope of representation. Clients and lawyer limit the scope of representation. The client decides the objectives, the lawyer decides the means. Limiting scope means really that the lawyer agrees to represent the client on only on specific issues. Either it's going to be draft a contract, review a lease, prepare a will, and so forth. The limitation must be reasonable and the client must give informed consent. When it comes to authority in a case, the clients and lawyer decide different things. The client can decide whether to file a suit, to settle a case, plead guilty or not guilty, in this case, plead guilty in a case or not guilty, and appeal. The lawyer, however, can decide which witnesses to call, arguments to make, motions to file, strategy of the case in cross-examination. When it comes to communication, the lawyer must keep client informed, respond promptly when there's a request of information, explain matters sufficiently, and inform clients of any settlement offers.